Hi, I'm Anthony Alder from Alder IP, and welcome to another episode in the IP series. Today we'll be talking about fair dealing and fair use in the copyright field. The really interesting thing about fair dealing and fair use is the fact that fair use is a concept that's only used in North America. It's only used in USA. When you're talking about fair use, quite often clients come in and think that they have an automatic right to do something just because it falls into this category of fair use. In Australia, fair use doesn't exist. We have a concept called fair dealing. And fair dealing is very much more narrow than the American fair use concept. With fair dealing, you only have a few exceptions for copyright. The first sort of exception for copyright protection, and this is the most common one, is for research and study. So that means that you can copy people's work for the purpose of self-education, for study or research. But there is a big limit to this. You can only copy about maybe 10% of the work. You can't go through and copy an entire textbook, quite obviously, but you can copy little excerpts and that sort of thing, paragraphs, maybe a couple of pages just for your own personal reference, so long as you can't get those from any other source. The second kind of format is for fair criticism or review. So if you're using it as basis for an article that you're doing, you're critically evaluating somebody else's work, yes, you can infringe on their copyright by way of criticism or review. Okay. Now, but this is very particular, and it means that you have to attribute the author still, and you still have to acknowledge that they were the original author of the original concept that you might have copied, and you can't really copy any more than it's absolutely necessary. The third sort of concept here is also there's an exception for parody and satire. And parody and satire are very restricted under the copyright law. Now, parody means that it has to be for a humorous purpose. So you can copy someone's work and make a parody of it, but only for a really humorous purpose. Now, the problem and the catch with this one is the fact that the judge has to interpret it as being humorous. So if the judge doesn't think that this is in the best humor or it's not parody, then it doesn't qualify for this exemption. And some of these cases previously have been knocked out, partly because they didn't fall into the category of being a parody. The other one is also satire, and satire again is a very restrictive concept. And satire, it has to be ironic or sarcastic, and it can't be a form of just straight out imitation. So it has to be a little bit further than just straight out imitation. And sometimes when people do satire, they think that if I just imitate someone, that is satire. The next category is reporting the news, and quite obviously people can infringe copyright for purposes of reporting the news, but only so far as it's absolutely critical to get your message across. So you can't just holus bolus, just copy pieces of work and just pass them off as your own work, quite obviously, but you can report it as part of the news. Another exemption for fair dealing is if you format shifted something for purposes of giving disabled people more access to the material. So if you're format shifting, say, a book to an audio book so that blind or vision impaired people could actually listen to the book, then that would be okay. So long as that you weren't making that formatted shifted book available to people publicly for a commercial purpose. The important thing here is, particularly with the fair dealing in Australia, once you sort of step over the line of doing it for a commercial purpose, even though the initial purpose might have been purely innocent and you suddenly try and make money out of it, if you try and make money out of it, you're going to fall foul of a lot of these fair dealing provisions. They're pretty much just there for personal use and personal use only. The final category of fair dealing is for lawyers and accountants and professional staff, really. So professionals can copy things, but they can only copy things for the purposes of legal compliance, for tax compliance, or for any kind of rule compliance that they need for the government. So, for example, if I needed to copy a judgment from a court, I could do that. But I couldn't do it for making money, right? I couldn't reproduce all the court judgments and then charge people access to that without having a proper commercial license for it. So really, in summary, when you're looking at fair dealing in Australia, it's very much more restricted than fair use, the concept of fair use in the USA. We have to be very careful that we're not using it for a commercial purpose, or that we're not suddenly morphing the use into a commercial use where we're charging people money. For fair dealing to work, you really have to be in a restricted category where it's only for personal use and you're not really making money out of it. I hope this helps you understand a little bit about copyright and some of the thoughts behind fair dealing under the Copyrights Act in Australia. If you have any queries about copyright, please contact Alder IP or myself, and we're happy to help you out. Thanks for listening.